Hello, I'm Georgie Jalbo from Lexis PSL Private Client, and I have here Zoë Sive and Katie Newbury from Kingsley Napley. Zoë is a partner in the private client team and Katie a solicitor in the immigration team, and they're going to talk to us about the recent changes to the investor visa route. So Katie, just by way of background, could you briefly explain the history of the Tier 1 investor programme?
Yes, well, the UK's had a residency by investment programme for around 20 years. Until November of last year, that programme has allowed people to relocate to the UK on the basis of a £1 million investment. So they had to show those funds were available, and then once they were in the UK, put those funds into specified investments. As long as they maintained that investment for 5 years and then met certain requirements, they would be eligible for permanent residence. And thereafter they may be eligible a year later to become British citizens.
Okay, and so the programme has a long history. What triggered the recent changes to it?
Well, the value of 1 million has obviously changed a lot over the 20-year period, and the government felt that it was time to review this. In addition, there have been some concerns over how much value the types of investments, which are primarily in UK gilts and corporate bonds and equity in UK companies, was really bringing to the UK. And on that basis, they commissioned the Migration Advisory Commission, also known as the MAC, to look into the route, report on it, and make recommendations for changes.
Right, okay. And I understand the government took these recommendations on board, and a number of significant changes were made and came into force on 6th of November last year. Can you tell me more about those changes?
Yes, the changes that were implemented on the 6th of November represent the most significant overhaul of the route since its inception. The first and most fundamental change is an increase in the minimum level of investment from £1 million to £2 million. The second change was reflected in the types of investments that investors could make. So in the past, they had to invest a minimum of 75% of the total million, now 2 million, into UK gilts, corporate bonds and equities in UK companies. But the balance of 25% could be held in other assets in the UK. Most commonly, it was held in the home that the investor was living in. However, following the changes of the 6th of November, the full 2 million has to be put into UK gilts, corporate bonds or equities in UK companies. The third change was the removal of the loan option. So previously it had been possible for investors to rely on £1 million that had been loaned to them from a UK bank who had to confirm that the investor had assets of 2 million elsewhere in the world. That route no longer exists. The investor has to rely on funds which are under their own control from the start. There's a further change in that a previous requirement to top up funds, which meant that the portfolio which the investor invested into, if that dropped below £1 million due to market forces, they had to inject fresh funds into the portfolio. There has been an attempt to change that so that they no longer need to top up, prompted mostly by the desire to encourage investors to make riskier investments. However, it's been drafted in a very unclear way, and so we are hoping for that to be clarified shortly, because at the moment it's not clear exactly what investors are required to do. The final change has empowered caseworkers when looking at initial Tier 1 investor applications to question the source of the funds. If they're concerned that the funds derive from an unlawful source, or they have worries about the conduct or character of the person who's provided the money, they can make further inquiries and ultimately refuse an application. I should just clarify that these changes only apply to applicants who applied on or after the 6th of November 2014. Anyone who applied before that is still covered by the previous regime for Tier 1 investors.
Okay, so they're quite significant changes. Have you noticed a reduced appetite for the Tier 1 investor visa route since these changes came into force?
Surprisingly, no. Our experience thus far is that Tier 1 investors are still keen to come to the UK, still keen to use the route, and they haven't been put off. Obviously, the UK and particularly London remains very popular with high net worth families due to the education system, the relative economic and political stability, the preferential tax regime and the booming property market in London, to name but a few reasons. So there are still sufficient pull factors for prospective investors. One area that may impact investors is the removal of the loan route. Although it wasn't widely popular, it was used a lot by Chinese investors who struggle to get money out of China due to the currency controls in place. And Chinese investors had been making up an increasingly large proportion of the overall number of Tier 1 investors, so we may see a drop in the number of investors from China.
Okay, and just final question for you, Katie. Do you anticipate any further changes to the route in the foreseeable future?
Yeah, I mean, one thing that we do expect to see is clarification of these topping up rules, and that's very welcome. One of the real attractions of the Tier 1 investor route is that it's got an element of certainty. Obviously, if families are relocating and upping sticks, they need to know that they've got a clear path that they're on that won't change halfway through, and that they've got clear rules they can follow. And at the moment, that is lacking from the topping up provisions as they were amended in the 6th of November changes. In addition, we know that the government is consulting on potentially widening the types of investments that can be made, looking at potentially introducing a donation element whereby funds could go to charities that benefit the UK, looking at social enterprise, and also possibly riskier investments whereby an investor could provide startup capital to perhaps budding tech companies in the UK, which could potentially have a greater return but obviously greater risk. It must be said that there is an election coming up, and until we know the results of that, with immigration being such a politically hot topic, it's hard to predict what might lie in the future for the Tier 1 investor route.
And Zoe, what tax advice do you give to individuals coming to the UK under the investor visa route?
Well, one of the key issues that I find when I'm advising individuals who are coming in on the investor visa route is that there's a confusion in their mind between the immigration rules and the tax rules. So they think, for example, I'm not yet resident in the UK for immigration purposes, therefore I am not tax resident. Or they think, I do not yet have a British nationality, and therefore I am not domiciled in the UK, or conversely, when I get a passport, I will automatically become domiciled in the UK for tax purposes. Now, the tax rules and the immigration rules are quite separate in the UK. And so the first point I find in speaking to clients is to get them to understand that, and to understand that they may have a tax liability before their visa comes through if they've been spending substantial amounts of time in the UK. And so they should plan for their arrival as far advanced as possible. And that's particularly so because the UK tax year is not a calendar year but starts on the 6th of April. And so the best planning that can be done needs to take place often in the previous tax year. The second issue then to explain to individuals once they've understand that basic concept that the rules are different is for them to understand the building blocks for UK taxation, which is mainly residence and domicile. An individual who is resident and domiciled in the UK will be subject to tax on what is known as the rising basis of taxation, which is where all of their assets, all of their income and their gains throughout the world is subject to UK income tax and capital gains tax, subject to any double tax treaties. The advantage for many individuals who are coming in on the investor visa is that they will be able to elect for a different type of tax regime to apply, which is called the remittance basis. And this only applies to individuals who are resident in the UK but not UK domiciled. If they elect for the remittance basis to apply, then they will pay tax on their income and gains which arises in the UK. But in relation to their income and gains that arises outside the UK, they won't pay tax unless and until they bring that income or gains into the UK, i.e. they remit it to the UK. And a lot of the tax advice that we give to individuals coming in on an investor visa centres around these rules about the type of tax planning that they can do where they keep their assets outside the UK and the way that they can manage their investments and their accounts in a tax efficient fashion in order to bring funds into the UK without then triggering a taxable remittance. Another point that individuals need to understand is the inheritance tax rules. which is focused almost solely on the domicile, their domicile as opposed to their resident status. For inheritance tax will apply where a UK domiciled individual, for UK domiciled individual on their worldwide assets. But for a non-UK domiciled individual, which is what many of the individuals coming in on investor visa will be, they will only be subject to tax on, to inheritance, their estates will only be subject to the inheritance tax on their UK situs assets situated in the UK and not their non-UK assets. Now, in order to be able to advise individuals as to whether this remittance basis will apply to them and whether the inheritance tax regime that will apply to them, it's important to analyse very carefully whether they will become resident in the UK and the point at which they'll become resident in the UK, and also their domicile status, and not just to assume that they are or they are not resident or domiciled in the UK. When analysing the residence position, it's a bit easier now than it was a couple of years ago, because as from 6th of April 2013, we now have a statutory residence test, which follows, where we can follow a sort of flow chart of different steps to work out whether an individual is or is not resident in the UK. From domicile perspective, one still follows the old case law, and it's not based on statute at this present time.
So thank you very much, Zoë Sive and Katie Newbury from Kingsley Napley.